Next one, performance of a contract. What is called performance of a contract? Performance of contract means both the promisor and promisee have fulfilled their respective obligation which contract placed on the them. When two parties enter in a contract, the promisor and promisee. Who is called as a promisor? The person who is accepting to do something. That is who that person is called as a promisor. Who is called a promisee? To whom the promise has been made is called as a promisee. Okay, so when the two parties enter in a contract, they have to complete their respective promise or obligation. That is called performance of the contract. For example, A visit a stationery shop to buy a calculator. The shopkeeper delivers the calculator and pays the price, and A is also pays the price. So this is called as completed contract. Okay, so sometime in case if the shopkeeper delivers the calculator and pays the price, the contract is said to be a completed contract by mutual performance. Sometimes, if one person is not ready to perform his respective obligation, the another person also not to perform. So we are going to see all the situation in this performance of contract. Example: A promise C to deliver. A promise to deliver a goods to B on a certain day on a payment of rupees 1,000. A expired before the contract date. So A representative are bound to deliver the goods to B, and B is bound to pay 1,000 rupees to the A's representative. So what is that? Actually, the contract is between A and B on a certain day of payment of rupees 1,000, but before the day A dies. So who will be doing this performance? The particular representative. So in this title, we are going to see who are the parties can able to perform the particular contract in case if the particular promisor or promisee is not available. There are basically two types of performance of contract. So actual performance and attempted performance. So what is called actual performance? When a promisor to a contract has fulfilled his obligation in accordance with the terms of contract, the promise is said to be have an actually performed. For example, if two parties enter in a contract, one party is completing his respective promise, the another party also completing respective promise, that is called as a actual performance. For example, see here, A agreed to deliver 10 bags of cement at B's factory and B promised to pay price on delivery. A delivered the cement on a due date, B also make the payment. So in this example, you could able to view that both the person have completed their respective promise. That is called as a actual performance. Then what is called attempted performance? Attempted performance in the sense either two parties in a contract might yet to perform the contract, or any one party might have completed the contract, then another party yet to perform. For example, I'm having a car. Okay, I want to resell it. So I'm asking one of my friend, would you buy my car for 2 lakh rupees? He agreed. Okay, so in this case, what I did, I hand over the car. I hand over the promiser, I hand over the car. But my friend, she asked some time. She said, I will give you 2 lakh after a 1 week. So in this case, from one person, from one party, the promise is completed. Whereas another party, it yet to complete. This is a one example for attempted performance. Whereas the second example, in the same example, I agreed to give a car, she agreed to give a money, but the performance is yet to be performed. For example, even I did not hand over the car, even she did not give her money. Do you understand? So in this two, there are two types of attempted performance can be made under the performance of contract. For example, see, A contract to deliver to B 100 tons of basmati rice at his warehouse on December 6, 2015. A takes the goods to B's place on the due date during the business hour, but B, without assigning any good reason, refused to take the delivery. So in this example, as per the contract, what happened? A takes the goods and delivered the goods at the B's place, but B only is refusing to accept it. So this is called attempted. Attempted is either one party might have completed his particular performance, or both the party yet to complete their particular performance. See, under the Indian Contract Act 1872, there are certain types of contract is there: executed contract and executory contract. So what is called executed contract? When both the party have completed their respective promise, that is called as an executed contract. Whereas what is called executory contract? When both the party yet to perform, or any one party yet to perform, that is called as an executory contract. So it is also somewhat coming under attempted performance. So here in this example, A has performed what he was required to perform under the contract act in the case of attempted performance, but A is not responsible for non-performance of B. So what he can do? He can claim damages from the B for non-acceptance. some of the rules. See, if you students, if you take the performance of contract act, there are some possible two questions to be asked during the examination. One is what is called performance of the contract, and uh, what are the two types of performance of contract, by whom the contract to be performed and not. These are the basic questions. Apart from that, if you take section B or some section C question, they mostly the questions will raise like rules related to the performance of contract. So now we are going to see the rules whatever related to the performance of contract. When no application is to be made by the promisee and no time is specified. For example, when two parties entering in a contract, the both the party has to clearly mention, they have to clearly mention at what time they have to perform the contract, or in which place they have to perform the contract. For example, I'm visiting Saravana store. Okay, I have ordered some home appliance. I could not able to carry the goods along with me. Okay, so I have asked the particular shopkeeper that will you do the home delivery? He accepted. Okay, so in this situation, what are the things I have to do from my point of view? As a customer, I need to say at what time he has to deliver, where he has to deliver, when he has to deliver. The three basic information I need to give. Okay, that is very much important from customer point of view. So same way, the seller, the promiser also, they have to ask the particular customer the details of the performance of a contract. So in this example, see here, Shikshi take a loan of rupees 10,000 from Shivani and says that she will return it to her when she receive her next salary. Here, the reasonable time for performance of the contract is after Shruti receive her next salary. So she has mentioned, indirectly she mentioned that at the time when she is receiving the next month's salary, she will return the money. So that is called as performance of a contract. When no application is to be made by the promisee, no time is specified. Again, I'm telling you, there are two parties in contract, promiser and promisee. Who is called as a promiser? The person, one who agreed to do something is called as a promiser. Then who is a promisee? Agreed to whom? Mean for what purpose? To whom this particular act is going to be done is called as a promisee. The person who is accepted is called as a promisee. When time and place of a performance is specified, but no application is to be made by the promisee. So see the first one, when no application is to be made by the promisee and no time is specified. Indirectly, the promisee is telling at what time she will return the money in the example. Whereas here, when time and place of the performance is specified, but no application is to be made by the promisee. For example, Ankita promised to deliver goods to Ira on an advance payment of rupees 10,000. Ira made the payment and asked the Ankita to deliver the goods on 13th of the same month at her office at Tishri. Since the time is not specified, she should deliver it between 10 a.m. to 5 p.m. Assuming those are the regular code timing. If Ankita attempt to delivery after the business hour, then Era has the right to not accept the goods and ask Ankita to deliver again during the business hours. So you could able to understand what I'm trying to say. So in this case, the particular promisee has mentioned the date of performance. That means in the particular date, you can deliver the goods, but he has not mentioned the timing of the performance. So in this case, what the seller has to do, the seller or the promiser, what he has to do, he has to deliver the goods during the business hours. In case if you are not going to deliver the goods in the business hour, the particular promisee, they have a full rights to return the goods. Okay, that is called when the time and place of a performance is specified, but no application is to be made by the promisee. When performance is to be made on the proper place and time, but application is to be made by the promiser, the promisee of the performance. Manu agreed to supply Nishant 50 cartons of alcohol on 3rd November at his office. As per the term of the contract, Nishant would have to request Manu for the performance. Thus, on the due date, within a usual business hour, Nishant should request a Manu regarding the time and place for the supply of goods. So in this case, what happened? The Manu agreed to supply Nishant. So Manu is a promiser. He agreed to supply 50 cartons of alcohol to the Nishant on 3rd November. But as per the contract act, Nishant, he is asking the particular person and he is requesting him to deliver the goods. So this is called when the term of the contract say that the performance of a contract has to be made on a particular day, but the promiser will only to do when the promisee make an application to the promises not specified on the day. It means that when the promisee made some application, that means when the promisee requests, that time only the promiser will be distributing the product. Where no place is fixed and no application has to be made to the promiser by promisee. When the term of the contract does not specify the place where the goods have to be delivered and no request has to be made by the promisee for the performance of a contract, in such situation, it is a duty of the promiser to request the promisee of a place, reasonable time, and where the goods has to be delivered. So in this situation, where the promisee, the person who has given an order, who has paid the money, has not specified where the goods has to be delivered and at what time he has to deliver. Now, in this situation, it is a seller's responsibility to make a call or to confirm with the promisee where the goods has to be delivered. For example, Sheila entered into a contract with for supplying 100 cartons of a gram flour to Anu on 5th September at a specific price. On the due date of a performance, Sheila must apply and request Anu to determine the place and time for delivering the goods. So do you understand? So see, this performance of contract has to be followed by both sides, both promiser and promisee. Sometimes promisees will communicate properly at what time and which place they have to deliver. All the conditions they will say, but sometimes they will not. So it is not like a void and it is not a punishable. Okay. So in case if the promisee, they are not communicating proper communication about the delivery of the goods, performance of the goods, it is a responsibility of the promiser to ask the promisee. That is very much important. When the performance has to be made in the time and manner specified in the promisee, sometime the promisee clearly mention at what time he has to deliver, in which place he has to deliver, why is there any specific reason to be delivered. So in such a case, the promiser, he has to follow that. Okay. Example, Pranku's son's in the hospital. Okay, Pranku's son is in the hospital and needs money for his son's operation. Harshal owes money. Owes means given. Harshal owes money to Prankur and agreed to repay him it in any place or time decided by Prankur. In this case, Prankur has the liability to ask for the performance of the promise in any manner, at any place and any time. Do you understand? For example, a similar example I will give you. One of my friend, she is in emergency mode. She is asking money for some hospitalized reason. So she asked 1 lakh rupees. Then I said, okay, I'm ready to give you. I have given her 1 lakh. Since she's in a emergency mode, she doesn't ask me where to give and all. She itself voluntarily, the promisee itself voluntarily informed to the promiser that uh, within once this operation get over, I will return back you the money whenever you ask. Okay. So in this case, the promisee has given a promise like to the promiser, like whenever you ask the money, wherever you ask me to come and give a money, I am ready to give. So that kind of a statement is given by the promisee. In such situation, the promiser, myself, the person who has given a money, have a full right to request the promisee to return back the amount at my convenient time. The consequence of failure to perform the contract at a fixed time when the time is essential. Sometime, if the promisee has given a specific place, specific date where the performance to be done, if it is not followed by the promiser, what are the things will happen? If an act is done with a stipulated time, the contract become voidable at the opinion of promisee, provided the intention of the party was the time should be in the essence of contract. Okay, always the performance of a contract to be done in the stipulated time, which is mentioned in the agreement. In case if it is not done, then he is responsible. So some of the case study is given here. in Butra Chand versus Belch, 1915. The defendant promised to deliver an elephant to the plaintiff for the plaintiff means defendant. Okay, the defendant promised to deliver an elephant to the plaintiff for the capture of a wild elephant as a part of the Kahada operation. The contract provided that the elephant would be delivered on the 1st October 1910, but the defendant obtained an extension of the time till 6th October and yet did not deliver the elephant till 11th. The plaintiff refused to accept the elephant, sued for the damages for the breach. It was held that the plaintiff was entitled to recover the damages since it was proved that the time was the essence of the contract, since the defendant had tried to obtain an extension of a time. So can you able to understand? For example, I can give you some example. Okay, there is a family function at my home. Okay, there is some marriage function at my home. I am giving order to the person who is having a elephant to bring an elephant for my my family marriage function. I told him clearly that the marriage function is going to be held on June 10th. Okay, so I have given advance also. I have given a clear instruction that you have to bring an elephant on 10th evening because the function is going to be held on 10th evening. But later on, initially he agreed. Later on, after 2 days, he made a call and he's informing me I could not able to come. I told him actually 10th evening is a function. Please bring an elephant on 5th itself. Okay. So initially he agreed. Then later on he made a call and he was asking me, Madam, I'm having some other commitment. I could not bring the elephant on 5th. Can you give me one more day extra? Can I bring the elephant on 6th? I said, okay. Okay, bring elephant on 6th since the program is on 10th only, but you must bring an elephant on 6th. But what happened? He brought the elephant on 12th. My marriage, my particular marriage function itself got over. So there is no purpose. So in this case, what I can do, I can't able to give a money to him. Instead of that, I can claim a damage from him. This is called breach of contract. Okay, when one person is not fulfilling the condition, whatever is given, if it is not carry the valid reason, then the other person can sue him. Okay, the another example is here, another case study. In the case of state of Kerala versus MA Mathi in 2007, it was held that if there are any delays in the performance of a reciprocal obligation by an employer, the contractor gets the right to avoid the contract. But if he does not avoid the contract and accept the belated performance, he cannot claim the compensation for any loss sustained to him due to the delay in performance unless he give a notice for the same to delaying party. So these are the example for this. The intention of the parties. So whenever, so that's all the rules related to the performance of contract over. Next, the intention of the parties. So as per the Indian Contract Act 1872, the question of whether the time is of the essence of the contract not determined by the intention of the parties. The intention of the parties can be determined from the express words used in the contract, the nature of the contract itself, the nature of the property which form the subject matter of the contract, the surrounding of circumstance. Sometimes one person cannot able to fulfill the performance due to certain reason. The reason might be valid. That reason might be genuine. Sometimes the other party, the promiser, could able to accept it. So always we have to see the surrounding and situation and the reason and nature of the problem when the performance is not able to done by one party. See this case study. This is a case study. Case of Hind construction contractor versus a state of Maharashtra in 1979. The appellant entered into a contract with the respondent on July 2nd, 1955 for some construction work with the condition that the contract should be completed within 12 months from the commencement of the work. The appellant could not complete the work within a stipulated time, and the respondent cancelled the contract with effect from August 16, 1956. The appellant contended that the time was not in the essence and further on account of several difficulties. such as excessive rain, lack of proper road, means of approach the site, and completion was delayed. So I hope so you can understand the case. Again, I explain you. Actually, there was a construction, there was a constructor and builder is there. They entered in a contract with one particular person. Okay, at the time of entering the contract itself, he has given clear instruction that you have to complete this construction within a 12 months of time, within a year. At the time he agreed, the builder at the time he agreed, but he could not able to complete the contract within a 12 months. So the appellant, what happened? The person, he canceled the contract. He canceled the contract. He has not paid the money because the builder might have spent some money to do some construction till that last 12 months, right? So in this case, what happened? The builder and the appellant both were suiting, they are filing a case against each other. So this case is handled by the Supreme Court. The Supreme Court has decided the following aspects. The Supreme Court, in deciding that the time was not the essence of a essence in relied on two clauses of the contract. So actually, the Supreme Court has given two way of relief. One is power to grant an extension of a time because the builder has given clear explanation for the work which is not done by himself. Himself. Why? Because since the particular customer has given only 1 year of time for the construction work, but within a year he could not able to complete the work. Why? Because due to a lot of reason like excessive rain, lack of proper road and means of approach site, and completion was delayed. So what Supreme Court has given a decision is either you can extend the time by considering the genuine reason what is given by the builder side, or else you can ask the compensation from the builder for the delay of the work. So two kind of suggestion is provided by the Supreme Court. So time can be made essence by the notice. Sometimes, see, whenever we enter in a contract, the particular contract to be completed within a reasonable time. Sometime, if the time is not mentioned, what's supposed to say? What's supposed to do in the sense? Either the promisor he has to ask the promisee to say the time, or else the promisee he has to inform the promisor within a day or within a how many days or in which place they have to deliver the goods. So it falls on both party. Okay. Sometime if the contract is based on the performance is based on some fixed period of time, the particular period, if you are not able to complete it, you can ask the particular promisor by extending the time with help of promise or proper notice or proper requisition letter. Okay, that is called the extension of time. Contract which need not to be performed. There are certain contract which need not to be performed. Example, novation, rescission, alteration, remission. So already we have discussed this topic under discharge of contract. My video is there in a YouTube. Even I have mentioned the YouTube link also in the description box. If you are not familiar with this point, you can go through the discharge of contract. So under that, the novation, rescission, alteration, remission, this explanation is given clearly in the under the discharge of contract. So anyhow, well, let's see what is called novation in a small recap. Novation in the sense, if you are doing any substitution in the contract, if you are doing any alteration in the contract, then sometime you may or may not accept it. That is called as a novation of contract. Okay. For example, here some case studies I have mentioned here. Ramdevajal versus Maji Devji. The court observed that novation takes place by introducing a new term in the court or by introducing a new party. The contract of novation requires a party to agree or discharge, because already in discharge of contract we have seen that novation can be done in a two-way, either changes in the subject matter or changes in the parties itself. So sometimes if any kind of a changes occurred in the existing contract, that can be either cancelled or cannot be executed or performed. Some of the example also you have mentioned here. A contract like in a partnership firm, liabilities of the old firm are taken over by the new firm. An agreement of a lease is where the tenant gives the lease to another party, make him responsible for the responsibility and the obligation that arises from these agreement, etc. For novation is to be in the effect, contract modification must go on the route of original contract held by the High Court in case of juggling culprit. So you can see the much more explanation for this case study in the Google. Then what is called rescission? Already told you, rescission means cancellation. When one party is cancelling the performance, the another party is also is having a full rights to cancel the contract. So what is called alteration? If they are doing any alteration, for example, if the contract is created based on some fixed period of time, within the period of time, if you are not able to complete the contract, you can ask the particular person to extend the time. You are doing a modification in the duration of the contract. Sometimes he or may mutually agree, then you can complete the contract. Whereas sometimes the party will not agree. Okay, so this alteration of contract is also plays a major role in the performance of contract. So as in the case, United Insurance Company Limited versus MKJ Corporation, it was held that the material alteration is that one which varies the rights and liabilities of the parties ascertained by the deed. What is called deed? We have seen in the Partnership Act, partnership deed. Partnership deed in the sense when the partnership is created, that they have to sign in a proper document. That document where all the partners sign in one document which clearly states their rules and regulation, roles and responsibilities, the share, the dividends, everything. The document which describes the partners, all this responsibility, everything. That document is called as a partnership deed. Okay, you will be studying under the Partnership Act. So under this partnership deed, if any modification done in this partnership deed, it is not valid, it is void. Okay, so if such kind of activity is involved in any kind of a contract, that cannot be executed. Then remission. So remission means what? Giving up. When two parties enter in a contract, one party, for example, I have given a 5,000 rupees to one of my friend for emergency situation. So I have given only 1 month of time to return back the money. She agreed. But after 1 month, she is returning back only 4,000, and she is explaining that I'm sorry, I lost my job. I don't have any other option to give her money. So and then mutually even I accepted. So I'm giving up. That is called remission. Remission means giving up. When the promisor itself mutually, due to the condition of the promisee, they are giving up the certain consideration. That is called as a remission. So one case study again I have given here. Kapoor Chand Gota versus Himaya Tekin Azam. B had executed a promissory note in favor of A, due to which A was offered a sum of rupees 27 lakhs in the full satisfaction of that note. According to the note, first he accepted 20 lakhs, but late asked for another 7 lakhs and sued B. It was held that in case was completely covered by section. So sometimes, see, you can't able to force the promisor to accept whatever the amount is given by the promisee. For example, as I told you, know that I have given a 5,000 rupees to my friend. She has returned back only 4,000. Either I can accept this, or what I can do, I can suit a case against her. Okay, it depends upon the person who is involved in the contract. So remission is a part or situation which is depends on the promisor. Okay. Extending the date of performance, as I told you that sometime the extending of a date of a performance is valid with the help of the proper document. The last topic, contract which need not to be performed. There are certain contract which cannot be performed, need not to be performed. What are they? For example, when its performance become impossible. Even this topic also we have discussed in the discharge of contract. When the contract is not in a possible to, when the contract is in impossible in nature, which cannot be executed, then you can't able to perform the contract. For example, one magician entering in a contract and he's asking me, give me 1 lakh, I'll give you the life to the dead body. Is it possible? No, it's impossible in nature. Okay. Then again, another magician is approaching me, give me 1 crore rupees, I will change this sand into the diamond. Is it possible? No. These are all is called impossible in nature. When the contract is impossible in nature, then you no need to perform. Next, when the parties to it agree to substitute a new contract, that means already told you novation. If you are going to do any kind of alteration in the existing contract, then you no need to perform it, because as per the Indian Contract Act 1872, at the time of agreement, what kind of rules and regulation we are following, what kind of conditions we are mentioned in the document, that has to be only followed. If you are going to do any kind of a modification or changes, if it is not mutually accepted by both the parties, then you no need to execute it. When the contract is illegal, or when it isn't resigned, or when the party is refused to accept the thing whatever is provided by another party, so these are the contract which no need to perform. By whom must contract to be performed? By a promissory itself, by the agent, by the legal representative, the third parties, and joint promisor. So mainly all the contract to be performed by the promisor only. If I am entering in a contract with one so and so person, in the sense, I need to perform my contract. In case if I am not in a position to complete it, or if I am not in a position to execute the contract, I can ask my one of my agent, legal agent, to perform it, or legal representative, or third party, or joint promisor to perform the particular contract. So already we have seen by whom must the contract to be performed. For example, A promised to pay B a sum of money. A may perform this promise either by personally by paying the money to B, or by causing it to be paid B by another person. This is also is accepted. So that's all the performance of contract over. So under the performance of contract, we have discussed what are the rules related to the performance of contract, by whom the contract to be performed, what are the contracts, what are the contracts need not to be performed, what are the conditions applied in terms of the intention of the parties and the extension of a time, performance and place, all the things we have discussed. So thank you. If you like this class, do subscribe. So if you have any doubt, you can see the video fully, and then the previous classes video link also mentioned in the description box. You can view it. Definitely it will help you. Thank you.